Good morning. Thank you very much for this opportunity to speak on our broken immigration system. I'm Elliott Kaplan. I earned my BA from Antioch University and MBA and JD from Whittier College. My legal practice involved the formation and execution of corporate strategies in legislative and regulatory matters, and the development of non-traditional solutions to a variety of legal problems in the United States, Great Britain, and Europe. My practice combined corporate crisis management and business strategy paradigms for dispute resolution, solving complex entanglements for clients around the world by developing countervailing legal and communication strategies that diminished opponents' leverage. In 1994, I co-founded Daniels & Kaplan PC with offices in Kansas City, Missouri, and Detroit, Michigan. Daniels & Kaplan concentrated in commercial insolvency, fair trade practices, and employment litigation, and acted as national counsel to a number of automobile manufacturers and importers, including Daimler Chrysler, General Motors, Volkswagen of America, and BMW. We also represented banks, pharmaceuticals, and retailers, including Walmart, Inc. I also authored articles in the Wall Street Journal, the Kansas City Star, Real Clear Politics, and Big Government. In the Trump administration, Attorney General William Barr appointed me to be a unit chief immigration judge in the U.S. Department of Justice Executive Office for Immigration Review. I sat in Richmond, Virginia, and heard asylum, withholding of removal, and many other immigration cases, writing and issuing decisions in hundreds of matters. The adjudication system for immigration processes cases once people are in the country rather than the policies about people remaining or coming into the country. I'm going to divide my speech today into two subjects. The first, how we got this way and what is broken in the courts. And second, some suggestions on how to improve the situation. The failure of the immigration system did not begin in the last few years, with the record number of illegal immigrants crossing the border and the record number of asylum cases. Immigration laws have been neglected since 1951, since they were adopted by the United Nations Refugee Convention in a noble endeavor in the aftermath of World War II and the Holocaust. It was signed in Geneva and supplemented by the 1967 New York Protocol. That was more than 56 years ago, and a lot has changed in our nation and the world. In 2007, the failure of our immigration system became apparent under the leadership of President George W. Bush, and in cooperation with the United States Senate and House, reform was attempted and passed in the United States House of Representatives. But the Senate dealt a fatal blow when Democratic Senators Reid and Obama voted against it. The system further eroded when then President Obama began loosely enforcing immigration laws and encouraged illegal immigration while at the same time building chain link enclosures to temporarily hold children separated from their parents. While former President Trump succeeded temporarily in at least somewhat stemming the tide, the border has been more porous than ever under the Biden administration. Currently, there are somewhere between 10 million and 17 million illegal immigrants in the United States, supported by your tax dollars. Now, I'm going to quote a lot of numbers today. I don't want anybody to think that they are accurate. They're not. They're the best guesses from any number of sources, and I don't think you can have an accurate number at any time because nobody's keeping count. According to Traditional Access Records Clearinghouse, TRAC, in December 2022, there were approximately 1,565,966 identified immigrants, of which 787,882 were waiting for a hearing before immigration courts. and 788,084 were waiting for hearings before the United States Citizenship and Immigration Services, USCIS. Those numbers change daily and do not include the over 9.4 million arrests at the border in 2022 alone, the last year for which complete records are available. The House Committee on Homeland Security reported for 2023 that there were 2.4 million encounters at the southern border, 3.2 million nationwide, of which 169 individuals on the terrorist watch list and 1.7 million known gotaways. Moreover, among those millions are thousands of incarcerated, convicted drug users, transporters, sex traffickers, murderers, and other criminals who continue to file appeals. And as of June 2nd of this year, 1.1 million immigration cases are waiting to be heard. There are also an unknown number of immigrants who were denied asylum in the United States immigration courts and after exhausting their appeals remain in the United States illegally because the Biden administration returned very few to their countries of citizenship. I have worked in the courts in Kansas City, Missouri, Fort Worth, Texas, Newark, New Jersey, Boston, Massachusetts, Arlington, and Richmond, Virginia. And I found that all the judges and staff behaved professionally and with courtesy, and every single judge was outstanding. They listened and did the best they could under the circumstances to prepare for and render decisions in cases. Many were frustrated because they could write all the orders they wanted, but the Department of Homeland Security often failed to enforce them. But in spite of the frustration, they still worked long hours doing the right thing. The judges are required to prepare for, hear, and decide 3 cases a day. DHS prosecutes the cases, but often comes to court only having received incomplete files in a few minutes prior. I understand that this is a result of the tremendous burden managing this volume of cases and the difficulty of obtaining cooperation from immigrants' home countries on facts that would impact the alien's ability to immigrate. It is not because DHS attorneys are not trying. They're making a great effort. The results are frustrating for them because they are forced to argue cases with little or no evidence. Judges can only issue decisions based on evidence, and when there is no evidence, the decisions will go against the government. In one case I heard, a U.S. Navy sailor who came to America on a valid visa was designated for removal in spite of still being enlisted in the Navy in a time of war and having served without any disciplinary actions. She was praised by her commanding officer in writing provided to the court. After 3 years, DHS could not provide any evidence to the court why the sailor should be removed. With no evidence against immigration, and after having served our country's military well, there was no alternative in spite of DHS's attorneys' insistence and aggressive behavior when there were no facts in support of removal. Based on these facts, I drafted a notice to terminate the notice of appeal. In reflection, I cannot understand why removal was being aggressively pursued. Perhaps there was something in the government's file that was not evidence and could not be presented to the court. Our current administration has encouraged DHS to dismiss cases, and when dismissals were not high enough, Secretary Mayorkas recently encouraged DHS to dismiss cases prior to November 2022, even if the applicant had criminal convictions. The courts only find out that DHS is going to dismiss on the court date and after staffs and judges spend hours preparing for hearings. DHS currently dismisses between 40 and 60% of the claims, resulting in hours needlessly spent and implying that the immigrants are seeing a judge and having their cases decided. Those aliens whose cases are dismissed are in nowhere land with no path to citizenship or a green card, but are encouraged to apply to USCIS for a work authorization, which is believed to be automatically issued. Attorneys will often try to overwhelm the court with unnecessary paperwork with impunity because immigration courts are not part of the federal court system, but rather administrative courts under the DOJ. As a result, they have no recourse to issue sanctions, otherwise known as contempt proceedings, to help keep cases on track. In one case I heard, an attorney filed 4,000 pages of evidence with the court. Voluminous evidence is often a mechanism to intimidate judges, and it's intimidating. You have to read it all. When I reminded the attorney that immigrations are not like pigs hunting for truffles buried in briefs and required him to cite each piece of evidence supporting his client's position among the 4,000 pages of evidence submitted identifying the evidence, the page, and the quote that the court should consider, the attorney did not identify a single page of evidence submitted. This behavior occurs all the time, and when it does, the system should allow attorneys to earn sanctions. Illegal aliens currently incarcerated for state or federal crimes such as murder or drug dealing are entitled to an asylum hearing and appeals rather than simply being deported. In summary, the problem has been going on for far too long. So long, in fact, that it has become a Gordian knot of antiquated laws, inefficient procedures, and under-resourced enforcement. I am now going to address some thoughts on solutions. There are no easy solutions to the crisis at our borders because of the legislative process and public interest groups. My suggestion will be limited to how to improve the adjudication of immigration cases in the courts. One of the biggest issues, in my opinion, is that immigration courts currently are administrative courts under the Department of Justice, making them part of the executive branch rather than under the judicial branch like other federal courts. This situation adds additional complexity to the status of the laws and appeals. Today, when an immigration judge issues a ruling, it is first appealed to the Bureau of Immigration Appeals, the BIA, which is the Immigration Appeals Court. It may then be appealed to the federal district courts and then to the U.S. Supreme Court, SCOTUS. IJ and BIA judge appointments are made by the DOJ. Therefore, each presidential administration has control over how immigrants are adjudicated, and the system is susceptible to political manipulation and poor management. In past immigration judges were traditionally provisionally hired for 1 or 2 years and then were converted to lifetime appointments. In my years, all IJs hired were converted. A recent example of political manipulation is this Attorney General's unprecedented non-conversion firing of as many as 20 Trump administration appointed IJs. When immigration judges are hired, their retention may be subject to review, and some have been removed for poor performance. However, under the Biden administration, has become politically, not necessarily performance related. It appears that all the non-converted judges were filed so DOJ could hire more judges in link with their DAI woke goals rather than the code of conduct for United States judges. The Congress needs to reform how immigration courts work and get politics out of justice. IJs, like bankruptcy, military, and Social Security judges, were created by the legislature and put under the executive branch. Like military and bankruptcy judges, immigration judges need to be moved to the judiciary. Moving the judges to the judiciary would also assist in the adjudication process as well. Most people believe we have national immigration laws. We don't. We actually have different laws for each of the federal circuits. Consequently, an immigrant applying for asylum could be found eligible in one federal district court and not in another. This is not the national system envisioned by the Congress and leads to forum shopping. While sitting in New Jersey, from Richmond, Virginia, I had an attorney apply for a change of venue to New York because New Jersey was inconvenient. I denied the application since the two courts are within 14 miles and also because the Richmond court was a WebEx court, so there was no inconvenience. As long as you have a computer or a cell phone in your home or attorney's office, the hearing could take place. When the applicant appeared before me, the motion was raised again. And during the hearing, I was told that his wife was unavailable for testimony because she was in California and in the process of applying for immigration in that court. I asked how New Jersey was inconvenient from New York, but California was not. I did not receive an explanation because there was none. Another opportunity for an attorney to earn sanctions. Under the judiciary, IJs could also be given the ability to issue sanctions. Judicial sanctions governing civil procedure were only adopted by the federal courts to secure the just, speedy, and inexpensive determination of every action and proceeding. The civil rules were last amended in 2022. The federal rules of bankruptcy procedure for many years were governed by the general orders and forms in bankruptcy promulgated by the Supreme Court and ordered dated April 24, 1973. Over the years, the bankruptcy rules and official forms have been amended many times. The purpose of court sanctions encompasses its exercise of authority to regulate the practice of law by protecting the public and maintaining the integrity of the courts and the honor of the profession. Violations of a court rule, or as a fine for contempt of court to be paid by the misbehaving party, are generally monetary, but may involve jail time, community service, or other types of punishment for professional misconduct. Misconduct in the immigration courts could include many attorney practices by immigration attorneys and attorneys for the Department of Homeland Security that should be sanctioned. Because the immigration system is a political nightmare, poor management slows adjudication, and the economic costs are staggering. There are many examples of poor management, but one that screams for attention is the tens of thousands of incarcerated drug and sex traffickers and criminals from thieves to murderers who appeal their convictions over and over again and are not removed. Removal under the present system is managed by the Department of Homeland Security. But because the Biden administration refuses to deal with them, they simply languish incarcerated, or in the case of non-incarcerated immigrants, on the streets with no legal means of supporting themselves, their families, and their children, which can only lead to unfair employment, crime, or both. Appeals are not a constitutional guarantee, but incarcerated aliens file endless appeals to allow them to remain incarcerated, hoping they will be freed by political or appellate court decisions. Procedural due process does not require states to allow appeals from criminal convictions, but does impose requirements on appeals if a state chooses to authorize them. The Supreme Court has reaffirmed that holding, stating that when a state does provide appellate review, it may not condition the privilege as to deny it irrationally to some persons, such as indigents. Aliens are deportable who were inadmissible at the time of entry or adjustment of status. Our President in the United States, in violation of the Act, had violated the terms of their immigration status have violated the condition of admission or have their conditional residence terminated. Deportable crimes include crimes involving moral turpitude, aggravated felonies, drug crimes, firearms offenses, and crimes involving domestic violence. Additionally, drug users and drug addicts are deportable without the need of a criminal conviction. An alien is deportable upon conviction of a single crime of moral turpitude, provided that the criminal activity occurred within 5 years after admission and the conviction is for a crime for which a sentence of 1 year or longer may be imposed. An alien is deportable upon conviction of more than one crime of moral turpitude, not arising out of a single scheme of criminal misconduct, regardless of whether the convictions were in a single trial. The Seventh Circuit, which reflects the majority of courts and consistent with the BIA, holds that two crimes could be treated as a single scheme. The Seventh Circuit went on to find that two offenses were not part of a single scheme of criminal misconduct when the act of robbing 6 people at one poker game would be a single scheme even if it led to multiple convictions. The Ninth Circuit disagreed in a case when the issue of whether 2 bank robberies occurring within 2 days of each other at the same bank and the aliens planned both robberies at the same time, thus constituting a crime arising out of a single scheme of criminal conduct. The court held that because the 2 crimes were conceived and planned at the same time, they constituted a single scheme of criminal misconduct. Aggravated felonies were the chief criminal deportation ground under moral turpitude. Beginning in 1988, Congress added aggravated felony as a new limited ground for deportation, and in 1990, they expanded the scope of aggravated felony to include non-political crimes of violence for which a prison sentence of at least 5 years was imposed, and stated that an alien who is convicted of an aggravated felony at any time after admission is deportable. One district court concluded that mere possession is not a felony, since South Dakota views this felony as similar to simple possession, but if the state crime actually fell within the general term of illicit trafficking, the state felony conviction would count as an aggravated felony. The judicial districts have difficulty deciding what an aggravated felony and crime of violence are. The court considered the meaning of crime of violence when an alien who lived in the United States for 20 years, 13 as a permanent resident alien, when he was charged with 2 counts of DUI causing serious bodily injury under a Florida statute. The alien was ordered removed from the country by the immigration court, a decision that was sustained by the BIA. The Ninth Circuit concluded that even though Florida had criminalized DUI causing serious bodily injury and only required negligence, it was much less natural to say that a person actively employs physical violence against another in an accident. Addressing the issue, the federal district courts adopted the categorical approach. With few exceptions, immigration authorities must use a categorical approach to determine whether a criminal conviction triggers a ground of removal. The general rule is that the categorical approach is required where the Immigration and Nationality Act uses the statutory term conviction. Some state courts have adopted the categorical approach. Competent use of the federal categorical approach may be the single most important defense strategy available to immigrants convicted of crimes. Let's say you have a client who comes in who has an Iowa conviction for burglary, for which she was sentenced to 16 months. You know that a burglary conviction with a sentence of a year or more is an aggravated felony for immigration purposes. But do you know whether her conviction is an aggravated felony? As every offense a state labels burglary is an aggravated felony if a year or more is imposed? No, it isn't. And this is the core of the categorical approach. The title of the offense, burglary, theft, assault, does not control. Instead, we take a three-part detailed legal analysis based on 1, the elements of the offense the client was convicted of, 2, the minimum conduct necessary to commit it, and 3, the definition used in the removal ground. It is not my intention to review all the elements of the modified categorical approach, because a typical primer on sorting it out is over 40 pages long. If and how it applies, and if it is often argued on appeal, and the determination takes many hours. Nevertheless, with thousands of incarcerated criminals and hundreds of thousands of crimes in all 50 states, the IJs must make a determination in every single case if and how it applies, and it is often argued on appeal, and the determination takes many hours. The Congress could eliminate the tens of thousands of hours required of judges to make a determination by defining with particularity crimes of moral turpitude. Among the glaring issues in the law is the qualification for asylum was either poorly drafted or has evolved into a system of ridiculous results, or both. Immigration judges hearing an application for asylum have 3 choices. They can grant asylum to an applicant, allowing them to remain in the United States, work legally, pursue citizenship, and eventually sponsor their families to immigrate legally. Grant withholding and allow immigrants to remain in the United States and work legally until the situation in their country of origin changes sufficiently for the State Department to determine that they should be returned to it. Deny their application, ordering them returned to the country of origin subject to appeal. Asylum applicants must prove a reasonable probability or a well-founded fear of future persecution on account of race, nationality, particular social group, or political opinion by the government of their country of citizenship, otherwise known as a 10% chance of persecution. If asylum cannot be granted, then withholding can be if there is a 50% probability. Temporary protection status, TPS, is granted by the administration and operates like withholding. It does not provide a path to citizenship, but it does allow immigrants to work lawfully, pay taxes, and educate their children until DHS determines that the lawful system of government has returned to their country of origin. The overreaching problem for asylum, withholding, and TPS is most of the aliens today are from countries that are failed states, in which the persecution is not from the government, but likely from criminal gangs or cartels, for which no lawful system of government is likely to emerge anytime soon. The problem with TPS is that I could not find a single example of aliens granted TPS ever having been returned to their country of origin. So perhaps a grant should be limited in time. Immigration laws were intended to react to state persecution in response to the Nazis killing Jews, Catholics, homosexuals, and other political enemies. Today, it's not the states. The states don't exist. It's the gangs. By moving immigration courts under the judicial branch, politics could be removed from the issue. However, one of the most significant issues is a complete lack of transparency. Federal court decisions are open to the public. The immigration court decisions are sealed. Congress should consider allowing all immigration proceedings to be available to the public by making the hearing videos, transcripts, and decisions available to the public. In summary, the solutions needed are: 1, reform asylum laws through legislation that makes them a national system responsive to issues facing America and the world today. 2, reform immigration courts by allowing IJs to issue sanctions for bad behavior by immigration and government attorneys. 3, take politics out of the system by making it a national system governed by the judiciary and not the executive branch. 4, keep Americans informed by allowing public and press access to immigration courts unless national security issues are involved. And 5, make administrative appointees accountable. Thank you very much for your time today. I hope you learned something, and God bless the United States of America and our people.